Welcome to our deep dive. We're going to be exploring the wild ride that is the history of the Supreme Court.
Wild ride is right. And you know the best part? You don't need a law degree to understand it.
Nope, not at all. And we'll prove it to you. Ready for some seriously cool trivia?
I'm always ready for some trivia.
Okay, so how about this? The number of justices on the Supreme Court. Not actually fixed by the Constitution. Crazy, right?
Seriously. And for years, you want to know something even crazier? They didn't even have their own building.
It's mind-blowing how different things were back then.
Totally different. So let's rewind all the way back, like way, way back to 1789, the Constitution, brand spanking new. And then Congress passes the Judiciary Act.
The Judiciary Act. That was huge. It was the blueprint for our entire federal court system, not just the Supreme Court.
Oh, yeah, the whole shebang. And think about this. The U.S. was just a baby country then. They were still figuring out how to balance power between the states and the federal government.
It was a delicate dance. And the courts, well, they were a big part of figuring that out.
Absolutely crucial.
You know, there's something about the Judiciary Act that just blows my mind.
What's that?
It was the first act of Congress to be partially struck down by the Supreme Court itself. Later on, of course. Talk about foreshadowing.
Oh, that's a good one. The court, even as a newbie, was like, hey, we've got a say in this too.
They were not messing around. Okay, so we've got the court set up. But fast forward to 1790, New York City. Picture this. The very first Supreme Court meets. And guess what?
No cases.
No cases. Can you imagine that? I mean, talk about an awkward first day at the office.
Oh, I can only imagine the crickets chirping in that courtroom. It makes sense, though, right?
Yeah, how so?
Well, the court's role was still a big question mark. Nobody knew exactly how this whole thing would play out.
It took time for people to understand how the court would fit into this whole government puzzle.
Exactly. A brand new country, a brand new court, and everyone's trying to figure out what it all means.
It's like they were writing the rule book as they went along.
Pretty much. So finally, the first case comes along in 1791, Van Staffhurst versus Maryland.
A historic moment. But hold on, fun fact alert.
Yeah.
The first recorded decision was actually West versus Barnes, also in 1791.
2 cases in 1 year. They were making up for lost time, I guess.
Right. But why the difference? You think maybe some early record-keeping issues?
Maybe. Or perhaps some juicy behind-the-scenes drama we don't know about.
Oh, now that's a story I'd love to hear. It makes you realize how much the court's procedures have changed over time.
Oh, absolutely. It wasn't always this well-oiled machine we see today.
From crickets in the courtroom to a full docket. Speaking of drama, let's talk about the case that really shook things up. Chisholm versus Georgia. 1793. This one caused a major uproar.
Oh, yeah. That was a big one. The court basically said, we can hear lawsuits against states.
The states were not happy. Can you imagine? It was a direct challenge to their power.
This was like poking the bear. The states were all about their sovereignty, and they felt like the court was stepping on their toes.
It all boils down to that core issue of federalism, right? That balance of power between the states and the national government.
It's a debate that's woven through the entire fabric of American history.
And the state's response to Chisholm, they didn't just sit back and fume.
What'd they do?
Boom. The 11th Amendment is added to the Constitution, specifically to protect states from those kinds of lawsuits.
Okay, that's a power move. They said, court, you want to play hardball, we can amend the Constitution.
It's incredible how one court decision can have such a ripple effect.
Right. And this wasn't just any ripple. This was a tidal wave, changing the Constitution itself.
It really highlights the power the Supreme Court can wield, even in its early days.
Yeah, from day one, they were a force to be reckoned with. So who were these legal titans, these first few Chief Justices navigating uncharted waters?
Well, we had John Jay, John Rutledge, and Oliver Ellsworth. Now, their time on the court, compared to what was to come, it was relatively quiet.
Quiet. You mean no bombshell rulings or headline-grabbing cases?
Not really. It was more about laying the groundwork, figuring out the rules of the game, establishing procedures, kind of like setting the stage for what was to come.
The court was finding its footing, testing the waters.
Exactly. And can you believe it? For over a century, they didn't even have their own building.
No way. So where were they holding court? Like a random basement somewhere?
Pretty much. They met in different cities, even used a room in the Capitol building for a while. It's wild to think of the highest court in the land just kind of bouncing around.
It really puts things in perspective, doesn't it? Their status, that image of a powerful, independent branch of government that wasn't quite there yet.
It was a slow burn, building their reputation brick by brick. But get this, the quiet times were about to end. Get ready. because things are about to get a lot more interesting when we enter the Marshall era.
John Marshall. Now that's a name that sends shivers down the spine of any history buff. This is where the Supreme Court flexes its muscles and really starts to leave its mark on the nation. Buckle up.
This is where it gets good.
John Marshall, this guy, oh man, he served as Chief Justice for over 30 years. Can you believe that? From 1801 to 1835.
That's longer than some people's careers.
It is. It really is. He was a legal rock star. Like, seriously, a legal mind that shaped the court's power, its whole role in the government.
Yeah, he's like the OG Supreme Court legend. He's the one who really gave the court its power punch.
You got it. And it was strategic. You see, Marshall was a hardcore Federalist, like really believed in a strong national government. And guess what?
His decisions reflected that.
Every single one.
Makes sense.
Yeah.
But wasn't he more than just a political player? I mean, I've read he was super charming, like really persuasive, and just a brilliant legal thinker.
Absolutely. He was known for that, his charisma, and he could really build consensus on the court. And his decisions, well, yeah, they were often controversial.
I bet. But they laid the foundation for a lot of the principles we still use today.
They did. They really did.
Okay, so let's talk about the big one. The one that put the Supreme Court on the map, judicial review. That's huge.
Oh, Marbury versus Madison, 1803. This is it. The case that established the court's power to declare laws unconstitutional.
I mean, that's a game changer. Before that, was there any check on the power of Congress or the president?
Well, that's the thing. This power, it's not even explicitly stated in the Constitution. Marshall, brilliant as he was, he argued it was implied. And the court, they bought it.
Well, hold on. So the court just decided they had this power? That's wild. Talk about a power move.
It was a turning point. From that moment on, the court could step in and say, hey, Congress, Mr. President, what you're doing, not cool. It's unconstitutional.
The balance of power shifted right then and there. And Marshall didn't stop there. This guy was a master of using the Interstate Commerce Clause to expand federal power.
Oh, yeah, that clause, the one that gives Congress the power to regulate commerce between states.
Right.
It was like his secret weapon.
Okay, so give me an example. How do you use it to increase federal power?
Let's talk about McCulloch versus Maryland, 1819. The big question, can the government create a national bank? The states were like, heck no. But Marshall,
He said yes.
you bet. And he used the Interstate Commerce Clause to do it. He basically said a national bank was necessary to regulate commerce, like super necessary.
So even though the Constitution didn't explicitly say anything about a national bank, Marshall found a way to justify it through a broader interpretation of this Commerce Clause.
Exactly. He was a master at connecting the dots. And then there's Gibbons versus Ogden, 1824. Steamboat traffic between states. Who gets to control it? Well, guess who wins that one?
The federal government.
Ding, ding, ding. Marshall, again, uses that Interstate Commerce Clause, making sure everyone knew who was boss when it came to regulating commerce between states.
It seems like Marshall was all about boosting the federal government, but didn't he also try to limit the power of the states?
He did. This is where things get even more interesting. He established the Supreme Court's power to review state court decisions, basically saying federal law, always supreme.
Whoa, wait a minute. The Supreme Court could overrule state courts.
You got it. And you can imagine not everyone was thrilled about this, especially those folks who were all about states' rights.
They must have been fuming.
Oh, they were not happy campers. But Marshall, he held firm. A strong national government, that was his jam.
It's like this ongoing tug-of-war between federal power and states' rights. It's a theme that keeps popping up throughout American history.
A theme that's still playing out today, even. Okay, now, get ready for a twist. Barron versus Baltimore, 1833. Here, the court rules that the Bill of Rights, those first 10 amendments that guarantee all those lovely liberties.
Right. Freedom of speech, religion, the press, all that good stuff.
Exactly. Well, the court said those rights, they only apply to the federal government, not to the states.
Hold up. So the states could just ignore the Bill of Rights.
That's what the court decided. And it had a huge impact. It meant states could potentially restrict freedoms like speech or religion without breaking the Constitution.
Wow, that's a big deal. I mean, that sounds like a step backward for individual rights.
It was definitely a decision that would have repercussions for years to come.
But even with that ruling, Marshall's legacy, it's pretty massive. He's up there with the greats, right?
Oh, absolutely. One of the most important figures in American legal history. He shaped the court, he shaped the nation, but even giants stepped down eventually.
So what happens when Marshall's era ends? Who takes the reins?
Roger B. Taney steps in as Chief Justice. And with Taney, well, a whole new chapter begins. And it's not a happy one.
Oh no, what happened?
Haney's time on the court was marked by one big looming shadow: slavery, and his most infamous decision. Oh boy, Dred Scott versus Sanford. That's the one they teach in law schools as a cautionary tale.
Oh yeah, Dred Scott. That's the case where the court said black people could never be citizens of the United States, right?
Yeah.
Like no matter what.
It was a terrible decision, just awful. A deeply flawed ruling, morally reprehensible, and it really helped push the country towards the Civil War.
It's hard to believe that happened. I mean, the Supreme Court, they're supposed to uphold justice. It's a dark stain on their history.
It really shows you the court, they're not perfect. They're a reflection of the society they exist in, and sometimes those reflections, they're pretty ugly.
It's a reminder that even the highest court in the land can get it wrong. Spectacularly wrong. So we've gone from the Marshall era, building up federal power, to Tunney's court and this huge national crisis over slavery. What happens next?
Well, the Civil War, it changes everything. And the Supreme Court, they have to figure out how to navigate this new landscape, this new world.
Okay, so we've seen the court find its way, then really flex its muscles under John Marshall. Then comes the Tunney era and all that tension and conflict over slavery. Civil War erupts, changes everything. What happens as the nation tries to pick up the pieces?
Well, the post-Civil War period, it's a massive shift, legally, socially, everything. The country's trying to figure out this whole Reconstruction thing. And the Supreme Court, right there in the thick of it.
And it's the 14th Amendment that really sets the stage, right? Ratified in 1868. Seems pretty simple on the surface. Citizenship for anyone born in the U.S., equal protection under the law.
Right, equal protection for everyone. You'd think, okay, problem solved, but, well, it's not that easy.
I can imagine. So what happens?
Defining what equal protection actually means in practice, that becomes the court's big headache. And how they interpret it, well, that has some serious consequences down the road.
I have a feeling they didn't always get it right.
Let's just say the court's track record with the 14th Amendment, it's a bit messy. There were some real setbacks for equality early on.
Like what? Give me an example.
Okay, take the civil rights cases of 1883. The court ruled that Congress, they couldn't outlaw discrimination by private individuals, only by the government.
Wait, so even though the 14th Amendment says equal protection, the court's saying it only applies if it's the government discriminating, not like a business owner or a regular person.
Exactly. That distinction, it had a huge impact, especially for African Americans in the South. It meant segregation and discrimination, they could still happen in a lot of places.
And then, of course, there's Plessy versus Ferguson in 1896. Separate but equal. That one really messed things up, didn't it?
It did. The court said racial segregation in public places, it was okay as long as the facilities were equal. But come on, we know separate was almost never equal.
It's crazy how one case can have such a long shadow, you know? Plessy, it basically gave the green light to Jim Crow laws in the South.
It's a prime example of how the court can get things wrong. And those wrong decisions, they can have terrible lasting effects.
So the court is grappling with these huge issues of equality, individual rights, all against the backdrop of a nation trying to heal from the Civil War. What happens as we move into the 20th century?
Well, new century, new problems. The rise of big business, industrialization, that creates a whole new set of challenges for the court. It's the era we call the Lochner era, named after a key case, Lochner versus New York, 1905.
The Lochner era. What was that all about?
It was all about protecting businesses, often at the expense of workers. The court, they were big on this idea of liberty of contract back then.
Liberty of contract. What's that mean exactly?
It's this idea that people and businesses, they should be free to make contracts without the government butting in. The court used it to strike down laws regulating working hours, wages, even child labor.
So if someone wanted to work like 16 hours a day for pennies, the court was okay with that?
Pretty much. They saw it as protecting individual freedom, limiting government power. But a lot of people said, hold on, this gives businesses way too much power and leaves workers with nothing.
It sounds a bit one-sided.
It was. A lot of people felt like the court was siding with big business and ignoring the struggles of everyday workers.
Okay, but it wasn't all bad news, right? Wasn't there something good that happened for individual rights during this time?
Oh, there was. This is when we start seeing the incorporation doctrine take shape. Remember how we talked about the Bill of Rights only applying to the federal government? Well, that starts to change.
Finally. So how did that happen?
With a case called Gitlow versus New York, in 1925, the court started saying some parts of the Bill of Rights, they also applied to the states. They used the 14th Amendment's Due Process Clause to do it.
So the court was basically saying, Hey, states, you can't just ignore the First Amendment and censor people's speech. You have to respect those basic rights, too.
That's the gist of it. It happened slowly, case by case, but it had a huge impact on individual rights.
So after the Lochner era, with its hands-off approach to the economy, comes the Great Depression. I imagine that threw a wrench in things, right?
You bet. The Great Depression was a total economic earthquake, and it forced the court to rethink its whole attitude toward government involvement in the economy. And then FDR comes along with his New Deal, and sparks fly.
FDR and the New Deal, that was a big clash, right?
Yeah.
The court versus the president.
Head to head. FDR, he's trying to use federal power to get the country back on its feet. But the court, still stuck in that Lochner mindset, they're striking down his New Deal programs left and right.
So it's like FDR saying, we need to do something big and bold to fix this mess, and the court's saying, yep, not going to happen, not on our watch.
Right. It was a battle of ideas, a constitutional showdown. FDR even tries this bold move, court packing. He wants to add more justices to the court, justices who will support his New Deal.
Didn't that go over well, did it?
It was a disaster. Congress shot it down. But then something interesting happens.
What happened? Tell me.
One of the justices, Owen Roberts, he starts siding with the more liberal justices. And suddenly, some of those key New Deal programs, they get a pass.
So the court, they kind of changed their tune.
They did. It's called the switch in time that saved 9. The court realized, okay, things are different now, the Great Depression, it's a whole new ballgame. And they started accepting a more active role for the government in dealing with the economy.
It's fascinating how the court, even though they're supposed to be above politics, they still react to what's happening in the world.
It's a constant balancing act, interpreting the Constitution in light of new challenges, new realities. And as we head into the mid-20th century, we enter what some consider the court's most important era, the Warren Court.
The Warren Court, that's the name everybody knows. The era of big civil rights decisions.
Forgot it. Earl Warren becomes Chief Justice in 1953. And it's a turning point. The court goes all in on expanding civil rights and liberties.
This is where things really start to change. What were some of those landmark cases?
Well, the biggest one has to be Brown versus Board of Education, 1954. The court says unanimously, segregation in public schools, it's over. Unconstitutional. Full stop. Plessy versus Ferguson, out the window.
Brown versus Board, that's the case that kicked off the civil rights movement, right? I mean, it's huge.
It was. It really helped dismantle Jim Crow in the South. And the Warren Court, they didn't stop there. They kept pushing for more individual rights and liberties. They used that incorporation doctrine we talked about, remember?
Right. So they're applying the Bill of Rights to the states, making sure those basic freedoms are protected at every level.
Exactly. Think about cases like Engel versus Vitale in 1962. No more mandatory prayer in public schools. Or Gideon versus Wainwright, 1963. Everyone gets a lawyer, even if they can't afford one.
And of course, Miranda versus Arizona in 1966. That's where we get the famous Miranda warnings. You have the right to remain silent.
That's the one. These decisions, they were controversial, sure, but they changed the way criminal justice works in this country. They protected the rights of people accused of crimes, and they put limits on police power.
The Warren Court, they really were a force for change. It's amazing how much they accomplished in just a few years.
It was a remarkable time. But even the Warren Court, their legacy is complicated. Some say they went too far too fast. Others say they didn't go far enough.
It seems like every era of the court has its own baggage, its own controversies.
That's the thing about constitutional law. It's always evolving, always open to interpretation. It's a constant dialogue about what our founding document means in a world that never stops changing.
So after the Warren Court, where do things go from there?
Well, the court keeps on trucking, of course. You have the Burger Court. They dealt with some big ones like abortion rights and Roe versus Wade, 1973. That one's still a hot topic today.
Roe versus Wade. Yeah, you can't talk about the Supreme Court without mentioning that one. It seems like everyone has an opinion on that case.
It's a landmark decision. It shows how the court's rulings can touch every aspect of our lives, spark these huge national conversations about what we believe in, what we value as a society.
So as we wrap up our deep dive into the history of the Supreme Court, what are the big takeaways?
I think it's pretty clear. The court, it's not some dusty old relic. It's a living, breathing institution. It changes, it adapts, it reflects the times we live in.
It's amazing to see how the court has shaped the nation and how the nation has shaped the court right back. It's a conversation that never ends.
And that's why it's so important to understand this history. It helps us make sense of the court's role in our lives. It lets us have informed debates about their decisions, the good ones, the bad ones, everything in between.
It's been an incredible journey. Thanks for guiding us through all the twists and turns of the Supreme Court's history.
My pleasure. It's always exciting to explore the story of this amazing, sometimes frustrating, but always important institution.
And to our listeners, thanks for joining us. We hope you've enjoyed this deep dive. We've just scratched the surface, but hopefully it's made you want to keep exploring. The Supreme Court, it's a story that's still being written, so keep learning, keep questioning, and keep the conversation going.